Parliament's Appointment Committee has vetted 6 out of 7 nominees to the Supreme Court with the spotlight firmly on competence, character and constitutional clarity. The process, marked by sharp exchanges and occasional light moments, saw Justices Senyo Jamefe, Dennis Dominic J, Gabriel Simon Subare, Philip Bright Mensah, Janapari Battles Kojo and Hafizata Amalboba answering a wide range of questions on law, ethics and national interest. However, the vetting of Justice Tawiah Ackaah Boafo was postponed following a petition challenging his nomination. Well, we'll get into that shortly. James Aveji has a wrap of yesterday's processes.
The first disagreement between Minority Leader Alexander Penyo-Markin and Chairman Bernard Ahiafo came up when the chairman admitted a follow-up question from Majority Leader Mahama Yariga on Penyo-Markin's probe as to whether or not there was wrongdoing when President John Mahama imposed salary restrictions on appointees who violated his earlier April 17 deadline for declaring their assets.
Chairman, this strategy by the majority, that they have their time. When it gets to my time, then I have follow-up. Anyway, I will yield to you. If you, Chairman, would want to allow these things, no problem. Follow up, and you think that you will be distracting me. I don't.
Honourable members, I believe everybody must be treated equally, particularly the leaders. There are instances where the minority leader called for a follow-up question and has been granted the floor to ask a follow-up question.
The ranking member again registered his protest when Bernard Ahiafo insisted that the nominee should not answer a question to the same matter which he believed was answered earlier. The two grew furious, with the chairman insisting that he cannot be intimidated by the posture of his ranking.
I cannot be intimidated by you. I'm a man with indomitable spirit. I still rule that a question has been asked. The nominee will not answer this question again. Pose another question.
Finally, the committee made headway as a nominee, Justice Hafizata Amalboba, established that there is a void created by the Constitution when it failed to provide specific sanctions for failure to declare assets within a specific period.
Honourable Chair, as has been stated, that there is no punishment regime, then what it would mean is that there's a lacuna in the law, and that must be addressed. It would need some deliberation on how this should proceed. For instance, presently we have the Constitutional Review Committee sitting. So if proposals are made to it on how to proceed, it can compile these proposals for the necessary action to be taken.
On other matters, she disagreed with assertions that Chief Justices influence the outcome of cases through the choice of justices they empaneled for some particular cases.
I believe that in the empaneling of judges, the Chief Justice performs an administrative function. Now, this administrative function is a function that has been given her by the Constitution. And I do not believe that it would or should influence the kind of decisions taken on the bench, because the Supreme Court justices of the bench are experienced, independent-minded jurists who should be able to take independent decisions.
The committee rose without vetting the final nominee, Justice Tawiah Ackaah Boafo, even though he was scheduled for Wednesday, June 18. It is unclear when that vetting will be done. James Aveji, Parliament House, Accra.
And joining us in this conversation is lawyer AJ Bafo. He was on the committee yesterday and also a member of the Constitutional Legal Affairs Committee. We're also trying to get a hold of Honorable Dafiamapo to join us in the conversation. But let me start with you, lawyer AJ Bafo. What has been your assessment of the vetting process so far?
In my humble view, it can be better. It can be better. And when I say it can be better, it is not I'm not speaking to the competence of the nominees,
right,
or the other conditions they have to satisfy under the Constitution. I'm referring to our own internal arrangement,
right.
the procedure, the processes and procedure. I think it can be better. Don't forget that we are being assessed by Ghanaians, and the general view of most Ghanaians is that the vetting is more like a rubber stamp. And so we would have to work hard to satisfy Ghanaians who more or less we represent, that indeed we are working.
Right.
And so it can be better. That's all I can say now.
Well, we're glad to have Honorable Roxanne Daffy-Amakpo joining us right now, also on this discussion. Honorable, you're welcome to our desk. What's your own view of the process so far?
Very professional. Indeed, it's an improvement on some of the work that we've done in the past, especially because the minority is spearheaded by the minority leader, have the leeway to ask as many questions as they desire. For instance, as a minority member on the committee, you are entitled to 3 questions. You are also entitled to 3 follow-ups. So substantively, that is 6 questions per person. When it gets to leadership, you are entitled to 5 questions and 5 supplementary to each. It used not to be the case. Now, when it comes to the minority leader, who is a ranking member to the committee, you cannot attest to the fact that he has so much leverage that people actually say that he can ask questions ad infinitum. In fact, he can actually decide that he has had enough for a day and then he will come and continue on the next day. In the past, even the minority leader was limited to time. And I have had the privilege of not being a member, but participating in the process. When I joined the committee as a friend, the chairman never gave me opportunity to ask questions. And the records will bear me out. So if my brother says that it can be better, I hope that he would have compared it to what used to be the standard in the past. In any case, we are vetting Supreme Court judges. We are vetting nominees to the Supreme Court, judges who are serving on the immediate lower bench, which is the Court of Appeal.
Right.
Now, what is the criteria for being promoted from the Court of Appeal to the Supreme Court? Essentially, it's about experience and quality. Because if you are not qualified to serve on the Court of Appeal, then certainly you can't be, you don't deserve to be a Superior Court judge. And Superior Court judges are judges who serve from the High Court, the Court of Appeal, and the Supreme Court. So I really don't know what question you'll be asking a judge who is being promoted to the Supreme Court, who already has served 38 years on the bench, rising from the magistracy level all the way to the Court of Appeal within the last 38 years. Right. There are some persons that the previous government, the immediate previous government, appointed to the Supreme Court, who spent nearly just 3 years as a Superior Court judge. So this is the distinction. This is the difference. All the men and the women who appeared before us, these six judges out of the 7 nominated, tell me which of them is it merited to be promoted to the Supreme Court? Just a single one. All of them merit it. And politics aside, this is all we are looking for.
Right. So, Honorable Ackaah, what will be the benchmark or key qualities that you're looking for if you say that it can be better? Okay, so
I think, very respectfully, you may have forgotten or missed what I stated in my initial remark. It wasn't in respect of the qualities of the nominees.
No,
It was
not
in
at all.
respect of our internal. So when you say, what qualities am I looking at? When I say it can be better, then very respectfully, unless you are very
I'm referring to the committee.
Good. To appreciate what we need to do, there is the need for me to correct certain misconception in respect of some of the things my brother has stated. The appointment to the Supreme Court is not a promotion. It is an appointment. If you are a Court of Appeal judge and you are being appointed to the Supreme Court, merely because you are going to a higher court doesn't make it a promotion. Judges are not promoted from one court to the other. It is a fresh appointment which is being made. That point ought to be settled. Very respectfully, it is not a rank. It is not a rank such that everybody at a lower court is automatically qualified to be sent to the Court of Appeal at some point. No, it is not. It is a fresh appointment. The second point that has to be made for us to appreciate what we are dealing with is that when you look at the Constitution of the Republic of Ghana, the only judges who are vetted on their appointment are Supreme Court judges. The interesting thing is that at all material times, all the judges have one common qualification consideration, or the considerations for the appointment of all Superior Court judges, right? Beyond or apart from the number of years are all the same. That is proven integrity, high moral character, right? Proven integrity, high moral character. Okay. And so if merely because you have served at a lower court, that is the High Court or the Court of Appeal, okay, then and we shouldn't have a problem with you being appointed to the Supreme Court, then we shouldn't even let such people come for vetting. We shouldn't, because you have already been a judge. And the consideration for your appointment is that you should be a person of high moral character and proven integrity. And because you have already been appointed to the High Court or the Court of Appeal, you are deemed to be a person of high moral character and proven integrity. The rest will be for you to satisfy us in terms of your number of years at the bar, for which reason then vetting is not necessary. But the Constitution doesn't look at it from that perspective. The Constitution is looking at it from the perspective that once a person is being appointed to the Supreme Court, that person should undergo vetting. Why is the Constitution saying so? Because the Constitution looks at the Supreme Court as a very unique court. Very unique court. Unique court in terms of its jurisdiction. And so there should be the mental capacity to be in that court. The jurisdiction that court exercises, most of our courts don't exercise that jurisdiction.
But lawyer, I thought you were giving us, I appreciate your submission there, but what did the committee do that didn't do well, that needs to be improved?
You appreciate it when you understand, when you appreciate the essence of the vetting. If you don't understand the essence of the vetting, you will not appreciate the need for the committee to improve upon its internal processes. Okay? When you look at the case of Attorney General versus Ghana Bar Association, Justice Pega said something that is very, very instructive. He said that when you look at the Constitution of the Republic of Ghana, what amounts to proven integrity is not spelled out. What amounts to high moral character is not spelled out. But between Parliament and the Council of State, they are able to put their heads together, right, and determine what amounts to proven integrity or high moral character.
Right.
The exercise we are undertaking, we don't go in consultation with the Council of State. It is for us to assess the judges who have come before us. The fundamental question then will be the time and the opportunities allotted to members on the panel. Are they sufficient for members of the panel to do a diligent work?
So you want the time to be improved?
Wait, we would have to compare to international best practice. When you look at the vetting of ministers, vetting of Supreme Court nominees in other jurisdictions, particularly the United States of America, is this what prevails there? No, it is not the allotment of six opportunity to ask 6 questions. No, you have time to deal with a Supreme Court nominee. And sometimes it takes days. Sometimes it takes days, 2 days, 3 days, because that office is a serious office.
Right.
It's a serious office. Now, my brother was also making reference to the past.
We'll have to be brief here, please.
My sister, very respectfully, I think that this will require a lot of...
I understand you, but if you could be very brief for me so I can go to Honorable Roxy.
Okay, so in my humble view, we need to review how we do the vetting. And we can only appreciate it once we understand the philosophy behind the need for the philosophy behind the vetting under the Constitution.
Right.
When you take into account the fact that not all the Supreme Court has a different jurisdiction from the courts where the nominees are coming from. It is not a promotion, it is a fresh appointment. And also the fact that in previous times, the opportunities available were more extensive than this time. Also, the number of questions somebody like Honorable Muntaka used to ask, we all saw it on TV. It is different. What is happening is different. The chairman overruling questions when they are very related. I think that the exercise of discretion is overbearing, right? And more trying to protect the nominees who should not be protected because they have experience, they have extensive experience, and so on and so forth.
Right.
The public is watching, and if care is not taken, they might think that we are just giving the nominees a pass.
Okay. All right. Let me go to Honorable Tawiah Boafo. I mean, Justice Ackaah was supposed to be vetted yesterday, didn't show up because of a petition. Can you tell us more about that particular petition?
Now, if you call me into an interview and you make it lopsided, next time I will decline. You don't ask me to speak within 3 minutes, and you ask him to speak. He spoke before I joined, and then you allow him to speak for another 6 minutes.
I'll plead your indulgence. You have the floor. You have the floor. You have the floor.
That is not fair.
You have the floor.
So, number one, let me refer you to Article 144(3) of the Constitution. It says, Justices of the Court of Appeal and of the High Court and Chairman of Regional Tribunals shall be appointed by the President acting on the advice of the Judicial Council. Now, in the case of the Supreme Court judges, it has this to say. Now, a person shall not be qualified for appointment as a Justice of the Supreme Court unless he is of high moral character and proven integrity and is of no less than 15 years standing as a lawyer, Article 1284. Now, if you look at the procedure for appointing a Supreme Court judge, the same standards are applicable for a Superior Court judge. Save that in the case of the Supreme Court judge, Parliament must give a pro-approval. Boafo has been talking about improvement. I was hoping that he would have said that the standards that were applied in the past were no longer applicable, and so there should be improvement. Or he wants an improvement on the present procedure in terms of ABCD. He didn't add anything. The procedure is that when the nominees are forwarded to Parliament, we cause to be published, a notice inviting memos and petitions or whatever it is that any person may have against any of the nominees. It was complied with. We only received one petition against Justice Ackaah Boafo. Now, when he makes the point that the questions that Muntaka used to ask is no longer, the same cases are not extended to the chief whip on the minority side, I disagree. I disagree because he's given the opportunity. It is he who has decided not to utilize it. So nobody limits him. In respect of the ranking member, you all attest to the fact that the Honorable Apenyo Marking is on record to have asked questions in excess of 4 hours. 4 hours. This matter is a topical matter among the people in the media, in the public, among the public. So to suggest that the latitude given to former minority leaders to ask questions is no longer available to the minority leader or minority members on the committee is absolutely falsehood.
Okay.
In fact, we are being accused of being overindulgent in terms of the latitude granted to the minority leader. But be as it is, if you are vetting a judge who is 66 years old, who has already served as a judge for 37 years, what are you going to ask? Well, really, unless you have evidence of some wrongdoing. Otherwise, then it is absolutely needless.
All right.
Because the man is serving at a level that is only a step below where he's supposed to go.
Right.
And I disagree with him when he says that the elevation to the Supreme Court from the Court of Appeal is not a promotion. It is. I will only agree with him if the person were coming from practice. That one, I agree that that's an appointment. The Supreme Court used appointment in context because it provides procedure for appointing people who are already on the Superior Court bench to be elevated once from the High Court to the Court of Appeal and to the Supreme Court, or straight from the High Court to the Supreme Court. That is why we, in practice, in the law, we call it elevation.
Right.
To be elevated is to be promoted, and Boafo knows this. He's just trying to play politics with the language.
So, Mr. Tawiah Boafo,
but in respect of Justice Ackaah Boafo, the procedure is that where a petition has been filed against a nominee, the petition must be determined.
Okay.
For us to establish whether or not it has a merit, the merit of which would torpedo the success of Ackaah Boafo being successfully vetted and cleared by Parliament. And that is the procedure we have adopted. So which other standard is Boafo suggesting that it needs improvement? The process is televised live. Members of the public get the opportunity to watch. Just that we don't allow them to participate by way of sending questions. But they do, because Boafo has been receiving questions from his constituents and his party people to ask.
So, Roxanne, exactly what is in the petition against Justice Ackaah Boafo?
Okay, the tenor of the petition and the essence was that there was a matter before Justice Ackaah Boafo, which he determined and entered judgment. And the petitioner claimed that as a party in that case, Justice Ackaah Boafo abused him verbally in the judgment.
Okay.
Now, we have perused the petition. We have also perused the judgment. What we have discovered is that Justice Ackaah Boafo actually quoted from an exhibit adduced by the petitioner as a party in the case. It is the content of that exhibit that he quoted verbatim as part of the judgment to make a point. So if the contents of the exhibit that he quoted were offensive, then those were not the words of Justice Ackaah Boafo. They were the contents of exhibits that form part of the court's records, which he relied on to make a point in some part of the judgment. But we'll deal with this matter. That is why the chairman and all of us saw fit to withhold his vetting until we deal with the petition and establish the merit or otherwise of it to be able to make progress. If it is meritorious, then we'll report back to plenary.
All right.
If it is not, then we'll do the needful and still report back to plenary.
All right. Okay. Grateful for your time here on our desk, gentlemen. We'll have to, suspend this conversation for lack of time. I'm so grateful for joining us on our desk. And moving on.